Hello students and welcome to this lesson. Today we are going to talk about the bankruptcy world, process, debt management and alternatives. In order to start our lesson, we are going to tackle some basics. We are going to speak about bankruptcy definition, how does the word bankruptcy work, the key terms related to the field of bankruptcy, the debt management, the alternatives, and at the end, the advantages and the disadvantages. So, in order to start, we are going to say that bankruptcy it happens when the company declares that it is unable to fulfill its obligation to creditors. Then the company liquidates all properties and bank account to pay as much as possible. So this obligation as possible and then exists the labor market. Although had a negative impact on the economy of the company owner, from another side it helps people who can no longer pay their debts get a fresh start by liquidating assets to pay their debts or by creating a repayment plan. So bankruptcy laws also protect financially troubled businesses. We are going to start this section by seeing what is bankruptcy. So bankruptcy is a legal proceeding initiated when a person or business is unable to repay outstanding debts or obligation. It offers a fresh start for people who can no longer afford to pay their bills. Now we are going to see how does this bankruptcy work. Bankruptcy offers an individual or business a chance to start fresh by forgiving debts that they can't pay. Meanwhile, creditors have a chance to get some repayment based on the individual's or the business's assets available for the liquidation. So bankruptcy also gives creditors an opportunity for the repayment when the assets belonging to an individual or for business are liquidated. So all bankruptcy cases are filed in federal court. The drill, in the most general terms, a judge examines the bankruptcy filing in order to determine a debtor eligibility and then decide whether to discharge it or not. A trustee here is appointed to represent the debt's estate. Most cases are handled between the judge and the trustee and don't require the debtor to appear in the court proceeding. So here are some key bankruptcy terms you are going to know. The first one, meeting. Also known as the meeting of creditors, you will be questioned under both by your creditors or the trustee about your financial situation. The following term is the credit counseling. Before you file for bankruptcy, you will need to undergo individual or group credit counseling. You will also be required to take a personal finance or before your bankruptcy can be discharged. The following term is the discharge. When bankruptcy proceedings are complete, the bankruptcy here is considered a discharge. At this point, any remaining debt you haven't paid is cancelled, and your creditors can no longer pursue the payments. There is the expend property. Bankruptcy requires you to sell assets in order to repay creditors. So some types of property may be exempt from sales. State law determines what a debtor may be allowed to keep. But generally, items like work tools, a personal vehicle, or equity is a primary residence may be exempted. There is an insecure debt, a debt for which the creditor holds no tangible collateral, such as credit cards. The following term is a line, a legal right for creditors to hold and sell debtor property as a security or a repayment of debts. There is a liquidation, the sales of a debtor non-extant property, the proceeds of which are then used to pay creditors listed in the bankruptcy. There is a means test. The bankruptcy code requires people who want to file So here the bankruptcy is going to demonstrate and they don't have the means to repay their debt. So this requirement is intended to curtail abuse of the bankruptcy code. There is a reaffirmation agreement. So the debt and your commitment to pay it is usually done to allow a debtor to keep a piece of collateral, such as a car that would otherwise be seized as part of bankruptcy proceeding. There is a secure debt, a debt backed by property such as a home or vehicle, which act as collateral. So creditors of secure debt have the right to seize the collateral if you default on the loan. And the last term is the trustee. Trustee is an individual or corporation appointed by the bankruptcy court to act on behalf of the creditors. So trustee is responsible for reviewing your petition and schedule and bringing action against you or your creditors in order to resolve the matters. So here we are going to see debts that can be forgiven in a bankruptcy. While bankruptcy can eliminate a lot of debts, it can wipe the slate completely clean if you have a certain type of unforgivable debts. So here are some types of debts that can't be eliminated, including the court order alimony. There is a court order child support. There is a reaffirmed debt. There is a federal tax line for taxes owned by the USA government. There is the government fines, penalties, or benefit overpayments. There is a court fines and penalties. There is a debt for personal injury case while intoxicated. There is a debt for willful or injuries to a person or property. There is a debt owed to a certain tax advantages repayment plans. And at the end, there is a debt for certain or cooperative housing fees. So when you are struggling with unmanageable debts, bankruptcy is just one possible solution. Some of the alternatives may also negatively impact on your credit, but usually not as drastically as filing for bankruptcy. So here just a few options in order to consider it. If you are overwhelmed with debt, something probably needs to change. It may be that you need outside help to break through and start making progress, or you need to have debt management plans. So the bankruptcy and the debt management plans are two very powerful tools designed to help financially stressed consumers in order to get out of the debt. But they work very differently if you are trying to decide between starting a debt management plan or filing for bankruptcy. So here are some key things you need to know. There is a debt consolidation. If your credit is still in a good shape and you can likely afford to pay your debt with less demanding repayment plan, so research debt consolidation loans and balance transfer credit card to see if the consolidation or the consolidating your debt can make the payments more manageable. So when it comes to what happened to your debt management plans is pretty straightforward. The credit consulting agency work with your creditors to reduce your interest rate and waive some creditors' fees. You pay the agency administrating your plan, who then pay your creditors on your behalf. The included accounts are paid in full, usually in less than 5 years. Now we are going to see the advantages of the bankruptcy. The first thing, it stops collection efforts. If you are fielding aggressive collection calls, you have been served for payment, or you are subject to wage a garnishment, filing for bankruptcy will stop all these activities. It can also give you the relief you need if you are or if you have exhausted all other alternatives, bankruptcy may be the only way to get the financial relief you are seeking about. So, depending on your situation, it could even give you a fresh financial start, albeit with some work ahead of your rebuild credit. Also, it can get a repayment plan that works for you. If you have been unsuccessful in negotiation or in a restricted repayment plan with your creditors, so bankruptcy may help you to get a plan that works with your budget. The second point is the disadvantages. It can ruin your credit, although bankruptcy can make sense for your overall financial well-being. It can take also several years to rebuild your credit history. As a result, you may need to put certain financial moves and hold until you can qualify for better terms. You can lose some of your assets regardless of which type of bankruptcy you choose. You may need to sell off some of your assets in order to cover your payments. That can include things like non-retirement, the investment, the jewelry, the furniture, and more than this. It's not a guarantee depending on your financial situation. There is no guarantee that you will qualify for bankruptcy. Even you do, you may not get the result of you're looking for. So, in order to end this lesson, we are going to read this bottom line or this small conclusion about bankruptcy. So, as a remark, before you make any decision about bankruptcy or any other from a debt reliefs, it's important to research your options, get reliable advices from a qualified credit counselor, and understand the impact your choices can have on your overall financial well-being.